and welcome to Number 5 Chambers' inaugural podcast to our conferences and seminars on all matters planning and environment. I'm Hashi Mohamed, a barrister at Number 5 and your host for this hopefully informative podcast. In the extraordinary times we find ourselves, delegates have been denied the opportunity to hear from our industry-leading barristers on the latest developments at the ICC this year in Birmingham. And for good reason. We are attempting to control the global pandemic and playing our part together as a country. But fear not, the world has not stopped. And your regular fix is now on hand, straight to your living room, your phone, your computer, or wherever you get your podcasts. We are keen to continue to provide you all as full a service as possible. Here, we offer a summary overview of the papers which would have been presented, from matters related to the Greenbelt, the latest on government policy, Rosewell review 1 year on, the annual monitoring reports of housing land supply, and of course, what do we do about COVID-19? But first, Richard Kimblin QC, our joint head of group. Richard, good morning.
Hello, good morning, Hashi. Hail.
It is quite remarkable, isn't it, really? Just a month ago, or even less, Richard, that we wouldn't have been imagining ourselves where we are now. Your reflections on the latest developments.
Well, I just thought back to where we were this time last year when we did the ICC event last year, just before Easter. We all thought then that Brexit was the thing we all had to talk about. For the last 3 weeks, I've heard nobody mention Brexit. Look, the situation we're in is truly grim, but I just take the view we've got to take the positives wherever we find them. We really do have to do that, and they're there. They're there to be seen. We've seen already that the appeal system is sorting itself out. Chambers has been really up front and central in that, and you'll hear more about it from JCB in due course.
Absolutely. And I also have with us Thea Osmund Smith. Good morning, Thea.
Good morning.
Obviously, Thea, was your reaction to what's been happening?
Well, our thoughts and best wishes, of course, are with those who are suffering at this time. We appreciate it's a difficult time for many, but the purpose of this podcast is to show that we at Number 5 are keeping calm and carrying on.
Absolutely. Thank you very much. Now, Richard, of course, the system hasn't stopped completely. The engines keep on running. And we have this recent, quite important case for many planners out there on paragraph 11 and the presumption. It's that Gladman case that you were involved in. Tell us all about it.
The Gladman case from about a month ago is a case about the paragraph 11 presumption. It's about that part of the framework where we find the policy which tells us what the presumption in favour of development, sustainable development, is. Look, the case is really about two noticeable changes that we encountered during the course of the last 12 months. We've noticed that after the 2012 framework, in the years after that, we had 20 to 30,000 dwellings per year allowed on appeal. Now it's around 10,000. Secondly, we've noticed that inspectors really rather routinely incorporate the downsides of development plan harm in that part of the paragraph 11 assessment, which requires them to have a look at whether or not the presumption in fact applies in that case. And that's all about that well-known phrase, whether or not the adverse impacts would significantly and demonstrably outweigh the benefits. And that's to be assessed, and this is the key, against the policies in the framework taken as a whole. What does that mean? Does it mean you just look at the framework, or does it mean you look at everything? Mr. Justice Holgate, in the case that we did about a month ago, says you look at everything. And so he's telling us that the framework, in fact, includes the development plan. When you're looking at that assessment against the policies in the framework, you have to read that to say policies in the framework and the development plan.
And Thea, what would you say? What does this actually mean then? I think you were also involved in that case as a junior to Richard. What does it mean for the planning balance?
It means that if the proposal harms a spatial strategy, even if it's out of date, that's something which can be taken into account in deciding whether the presumption applies in the case or not. And as the judgment makes clear, if the development plan is to be considered under paragraph 11D2, then all of it is considered. So there will always be policies that support a particular development and those with which it accords. Take, for example, affordable housing, social infrastructure, or even the housing numbers that the plan is planning to meet. All of those supportive policies also go into the balance, as well as those with which the scheme conflicts.
And of course, it's a really important case for so many people, and this is a judgment at first instance. Do we know whether this is now subject to appeal, Richard?
We do know that it has been appealed. The grounds went in within 7 days, and the skeleton argument is now filed. Quite what the progress of that appeal will be in current circumstances, we're unable to say. The reality is that there's lots of opportunity now for the Court of Appeal to pick things up and run with it faster, certainly so far as permission to appeal is concerned. But we would expect a decision on permission to appeal within a relatively short period for a case of this sort. In the planning court, it was expedited, went through the system very quickly. It's an important point. Do those words in the most important paragraph in the framework mean just what they say? Or do you have to read it with some extra words in there? That's kind of the big question.
Thank you very much to both of you, and of course getting us kicked off to our virtual ICC seminar. I hope you're all both keeping well. Thea, how are things in the self-quarantine world?
Very good, thank you very much. I'm learning to cook, so all very successful.
Fantastic. And what about the Kimblin household?
Hey, I just wrote a piece about what's going on in terms of staying at home, and I've discovered that I'm allowed out to go to my apiary. Did you know I kept bees?
I did know that.
I keep bees, and I'm allowed out to go and see them. So
is that essential? Is that essential, Mr. Kimblin?
The Department of Environment, Food and Rural Affairs sent a personal email to me, and if I spot an officer on the road and he asks me the question, that's my defence. And Hashi, I'll be straight there to you, looking to defend me on the prosecution.
I will try my best. Thank you, both of you. That is Richard Kimblin, QC, our joint head of group, and our esteemed junior colleague, Thea Osmond-Smith. Thank you very much to both of you. You are listening to the No. 5 Chambers podcast, giving you the latest updates on all matters planning and environment. And moving on very swiftly from the presumption in favour of sustainable development to government reviews, I have now with me Peter Goatley, Queen's Counsel, and Jack Smythe. Good morning, gentlemen.
Good morning.
Morning.
Now, Peter, first of all, congratulations on recently being ennobled to the High Table.
Well, thank you very much.
And you're about to tell us about the Raynsford Review. What is it about? What does it deal with?
The Raynsford Review, it was a Town and Country Planning Association review chaired by Nick Raynsford, the former Labour government minister who does know a thing or two about planning and housing. It dates from 2018 and was looking at the planning system rather more generally, and figuratively trying to hold a mirror up to it. Now, it's fair to say that some of the images that were reflected were not particularly flattering. And what it was looking to try and do was to reimagine a land use planning system that would meet a series of assumptions and principles. And housing was only one component of that. I should probably say that in looking at what it was saying and what we need to deal with today, almost everything we have to consider now has to be looked at through the prism of the current emergency and the economic environment which will follow it.
Yes, and absolutely. And of course, there is this target that we've always known about for 300,000 dwellings per annum by sort of the mid-2020s. Now, given the current emergency, how realistic is it that that will be achieved?
The short answer in the short term is it's not realistic. If you look back at the figures as to how well our country does at building houses, even in the heady days of the mid-noughties when everything was booming, just before the Great Recession, we were managing 220,000 homes a year, and it hasn't been the case. We've got anywhere above 250,000 homes for decades. So in the short term, it isn't realistic unless we make significant changes in policy and infrastructure in order to provide for that step change.
And Jack, do you think that sort of step change will have to involve, for example, allowing councils to start building housing?
Yes, I think so. To use the old adage, we all need to put our shoulder to the wheel. And it's not to say that councils or housing associations would be instead of housing developers, but alongside them. And particularly as interest rates are at historically low levels, it's a good time for the public sector to borrow, as good a time as any. And so now would be a good time for them to make a bigger contribution than they have in the past.
And Peter, what about the question of quality, really? I mean, how have existing policies really worked or not worked as it is in relation to both boosting numbers and maintaining quality?
It's always going to give rise to attention, not least of which is any changes of standards or requirements that look to enforce some form of qualitative change. Oddly enough, the most recent change that is probably directed to that is affected more by the process of building regulation control via minimum space standards rather than through the system of planning control. Has there been necessarily a maintenance of standards and quality? Well, I think we all know fairly public examples of main house builders who have had some difficulty with trying to increase numbers yet maintain quality. That's not a dig at certain house builders. I think it's more a reflection of the simple systemic difficulty of increasing volume and maintaining quality. So partly, what does quality mean? Well, it means amount of space, perhaps, for one. But of course, when we were looking at space and people were looking at space even a few months ago, things have changed since then. Now we're perhaps going to look rather more carefully at the amount of space that people have outside and not just inside their dwellings. Also, if you are going to enforce minimum standards of space, that normally means increasing the amount of built form. There will be a cost consequence for that, and will the system be able to provide for it?
That's a really interesting point. I mean, Jack, do you think the minimum space standards actually help us or hinder in making this progress?
I think on balance they help because it's no part of the planning system to promote and create inadequate dwellings. But as with many parts of planning, one has to approach the standards with a degree of flexibility. So by way of example, let's imagine you've got a office block conversion which will create a number of dwellings, but on a particular floor, those dwellings modestly depart from the standards. In those circumstances, if you were to slavishly and inflexibly follow the standards, that could jeopardise the entire project. So I think minimum standards are good, but as with all matters of planning, they should be approached with a degree of flexibility and discretion.
But is that really realistic? I mean, Peter, what do you think about that? I mean, can we really reproduce enough of the houses whilst maintaining a minimum space standards?
Well, that is still to be seen. We still have enough difficulty in producing anything like the number of houses we require, irrespective of quality controls, whether or not it's space standards or building for life or lifetime homes or any of the other standards that have been utilised over time. At the moment, we're nowhere near those numbers. Hence, we're looking at the way the government has moved on at trying to relax, for instance, permitted development rights.
Yeah. And how do we make the system a little bit better then, Jack, in terms of in principle? I mean, what does the future hold in that regard?
I share Peter's view that what I think we're going to have to move towards a level playing field, because it's difficult to justify, if we scale up these conversions, having a situation where certain conversions are permitted development in offices and therefore there aren't the standards, and yet other schemes for conversion require planning permission where the standards apply. So I think we're going to have to move towards that. And I think another area where things could be changed and improved is the SIL regime. So if you've got a developer under permitted development converting a huge office block into flats, micro flats, for example, the idea of no contribution being made is problematic. So is there a system whereby we could have SIL without replicating the planning application stage? And there's clearly a danger that if you start piling SIL obligations onto PD, arguably you start to kill the whole attractiveness of PD, which is meant to be quick and not being caught up in the planning system. But I think that is something which can be looked at, and I don't think it should be insurmountable.
Thank you very much to both of you gentlemen, Peter and Jack Smythe there. I hope you're both keeping well.
We're doing our best.
Yes.
And I might even go out for a run a little later, albeit only round my garden.
Fantastic. Thank you very much to both of you.
Thank you, Hashi.
Thank you.
You are listening to the Number 5 Chambers podcast, giving you the latest updates on all matters planning and environment. Satnam Chung now joins me. Sat, good morning. How are you feeling this morning?
Feeling a lot better, Hashi. Thank you very much.
Good to hear from you. Now, Sat, delegates will have been eager to hear from you and what you had to say about local plans and housing numbers and the question of soundness. Now, we know that particularly examinations were being stalled and stopped altogether before this current crisis that we're in. But before this all happened, what were the main fault lines?
Well, Hashi, there were a number of main fault lines. I suppose the most stark one out of all of them was that although the government, of course, is very keen on the plan-led system, we have a situation in this country where some authorities have simply refused to bring plans forward, either on time or at all. And listeners will all be aware of authorities who haven't had an up-to-date plan in place for years, if not decades. I mean, the example of York is often given, which has a plan dating back to the 1950s. And the difficulty we have in this country is that although authorities are supposed to have plans in place, up-to-date plans in place, there's really been no real incentive for them to have such plans in place. Now, whilst the NPPF, when he first came out, gave an incentive to some authorities, with the presumption in favour of sustainable development, where if there was no up-to-date plan, they lost control over housing and the location of housing. That incentive hasn't really worked for local planning authorities, which are greenbelt authorities, because they have decided to sit behind, or back behind, if you want to use that term, the government's commitment to saying that the unmet need for housing is unlikely to trump greenbelt, unlikely to constitute the very special circumstances that are needed to permit development in the greenbelt. And that has enabled authorities simply to sit back and not bring plans forward.
And that's interesting, because we've seen that happen, haven't we, in places like Sevenoaks, places like St Albans, and other authorities who have used greenbelt as a cover. Now, how do we see that then playing out? If they don't have any incentives, what can, for example, governments do? What can the inspectorate do? What can the appeal process do to incentivise them in another way?
Well, I think the South Oxfordshire saga, it has been very interesting. I think although it's taken a long time with the to and fro and the battle between the Secretary of State at the centre and the local planning authority at South Oxfordshire, although it's taken a long time, I do believe that the Secretary of State has crossed the Rubicon to some extent with South Oxfordshire. As you'll know, Hashi, that finally he has now ordered them to allow the examination to proceed.
This is the Secretary of State.
This is the Secretary of State, and it's very interesting that in the paper that was published just before the shutters came down with the current coronavirus crisis, the paper that he published, he made it quite clear that he's going to set a deadline for all local planning authorities to have up-to-date local plans, and he's expressly said that the government will prepare to intervene where local authorities fail to meet the deadline in accordance with the existing statutory powers. So I think what we're going to see in future is a much more decisive move by the Secretary of State, a much more timely move, and saying to local authorities, right, where are you with your plan, and issuing directions to make sure that the plan moves along rapidly to its 2023 deadline.
And finally, Sad, of course, do you think that that kind of decisive action will be precipitated a little bit quicker with this crisis? Because, of course, we know that we now have to, in the words of the outgoing chief planner, Steve Quartermain, we have to plan for that recovery. Do you think that kind of decisive action is going to be even more urgent now?
I believe so. I believe that this government now really has nowhere to hide, given the drastic nature of the situation that we found ourselves in and the huge impact that it's going to have on the economy. The government is going to try and use every lever at its disposal to kickstart the economy once we are out of this present crisis. And of course, we know from history that the construction industry and house building in particular has been a go-to sector for the government in the past, and I have no reason to doubt that it won't be the same in future. And one thing you'll want to do is to make sure that the planning system doesn't act as a brake on that.
Watch this space. Thank you very much for that, Sat, and just hope you enjoy your life in quarantine and wherever you are.
Thank you very much, Hashi. Thank you.
I'm now joined by James Corbett Bircher from our annex in Pimlico. How is self-quarantining at home, James?
It's going very well, very productive, and looking forward to planning for the recovery.
Fantastic. Well, your paper for the ICC was going to be about monitoring housing numbers and how the evidence might be presented at a Section 78 appeal. But before we get to that, you've been doing some really important work on the actions being taken to ensure that the whole appeal system does not come to a halt. Can you tell us a little bit about that?
Yes. So PINS's most recent letter from 25th of March states expressly that they are, quotes, considering whether it might be feasible to utilise technological solutions to enable events to proceed whilst ensuring fairness for all parties. Now, from a planning bar perspective, there's a growing consensus that video conference and audiovisual technology has a role to play in allowing appeal hearings and inquiries to proceed, subject, of course, to reasonable adjustments to procedure. Now, just about 10 days ago, which now seems like something of an age, a combined team from King's Chambers and No5 produced a paper recommending this as a solution. And now this has been taken up by the Planning and Environmental Bar Association Committee, PEBA, on which you and I are both fortunate to sit. And they're taking on that task of exploring this on behalf of the whole planning bar. They've convened a working committee, which includes a subcommittee of junior practitioners from 7 different chambers. And we're looking at technological aspects of this.
And so just tell me a little bit more about what are the kind of solutions that we're hoping to realise to get through this process?
Well, I think that what we're looking towards is a virtual hearing or virtual inquiry, which has 3 technical components. First, it will be based on a video conference platform hosted by PINS, perhaps Microsoft Teams or Skype for Business. Secondly, some form of webcasting or recording to ensure that proceedings are in public. And thirdly, electronic bundles. And so we're looking at all aspects of those. And of course, we'll await PINS's preferred solution so that we can advise on how that can be made workable and improve access for all participants in the process.
Well, thank you very much for all the work that you're doing on that front. And no doubt matters are going to be moving quite quickly. Now, to your actual seminar paper, Housing Land Supply 5 years' time. Now, you're obviously going to be talking a lot about this, and we're all going to be dealing with this over the next few years, housing land supply and evidence at Section 78 appeals. What are the kind of changes we're seeing in this area, and particularly as a result of the current crisis?
Well, I think as matters stand presently, many local planning authorities are going to be reporting delivery reductions in the next quarter and perhaps deeper into 2020. And that's obviously due to pure construction workforce supply chain issues, but also impacts in a more administrative level, for example, the sign-off of conditions. So the scale of those delivery shortfalls is going to depend upon the duration and the sort of severity of the crisis. And as planning policy is presently drafted, that would obviously impact on the deliverability of certain sites and the trajectories for larger sites. So I would anticipate the government is going to have to step in and provide additional guidance on how the deliverability test is supposed to be applied in a manner that properly boosts the supply of housing, plans for the recovery on the other side of this, but also obviously is fair to local authorities who were planning on different figures prior to the crisis breaking. So I would envisage that in addition to that guidance provided by government, we could see clarification in respect of the housing delivery test. We may see further clarification in respect to the use of annual position statements, and certainly some further policy announcements on the plan making front to meet the target date of 2023 for complete up-to-date local plan adoption.
So bringing all of that together, James, what we know is that we're being told to plan for recovery. We've just heard recently that these restrictions might still be here for the next 6 months. But how would a sort of virtual inquiry, if one can imagine one, looking at the question of housing land supply, how would one actually work in practical terms? Are we looking at, for example, a full day of cross-examination or roundtable sessions on housing delivery by video? I mean, practically, how is this all going to come together?
I think practically it's important to divide it up into 4 parts. Statements of common ground, proofs of evidence and core documents, the cross-examination component, and the roundtable part. And effectively, what the virtual inquiry will do is substantially front-load the evidence base on these issues, even more so than under Rosewell. Looking first at statements of common ground, I would envisage that these are going to become increasingly sophisticated and navigable with internal hyperlinks to the relevant evidence, and there may also be an automatic calculation table that's added to them, whereby an inspector can identify effectively the precise numerical impact of the deduction of individual sites from the overall 5-year supply figure. That will then feed into the structure and the length of proofs of evidence and the accompanying core documents. I think we can expect that PINS is going to enforce word limits rigorously and crack down on the length mass of appendices.
Yes, I think that will be quite apparent. And of course, that will require all of us to adjust the way we work, the way we think, the way we cross-examine, and crucially, how we conduct these hearings and inquiries. Thank you very much for that, James. Very useful tips. Hey, hello, Nina. How are you? In what wonderful green and pleasant land are you self-quarantining at the moment?
Morning, Hashi. I'm in the not so sunny today wonderful town of Oxford, but yes, very green, very pleasant, thankfully.
Fantastic. Well, thank you very much for joining us. We're here to sort of get your thoughts on the developments and the latest developments in particular on all matters green belt. Now, in light of the sort of recent case law, what are the tests that we're now learning about what councils have to apply when they're dealing with applications for development in the green belt?
Thanks, Hashi. What I'd like to talk about is the most important case that has been published recently, which is the Supreme Court decision in the Samuel Smith Brewery case. And that considered the correct approach to assessing visual impact of development proposals in the context of the impact on openness and whether that resulted in inappropriate or appropriate development. The issue is topical because it comes up time and time again. It's been subject to quite a lot of litigation, something which Lord Carnwath said was actually surprising because in his view, it was all a matter of planning judgment. So he confirmed helpfully that openness does not imply freedom from any form of development. And he referred back to the NPPF tests, pointing out that some forms of development may in principle be appropriate and compatible with the concept of openness. So in his opinion, a large quarry which may be visually unattractive, was nonetheless a barrier to urban sprawl. And so in terms of greenbelt policy, was no less effective than a stretch of agricultural land, and so was in compliance with the NPPF's tests on policy. So that's some helpful dicta from Lord Carnwath. But the most helpful aspect of the judgment is, and this won't come as any surprise to anyone who follows the trends in planning case law, it all comes down to a matter of planning judgment. So here in Samuel Smith, the question was how the inspector took into account the visual impact of the proposals. And just to remind listeners, the High Court decided that the inspector's approach was lawful because even though the specific visual impact of the development wasn't assessed in her report, it was a matter for her to consider how she ought to take that into account. The Court of Appeal overturned that decision, Lord Justice Lindblom saying she had to take into account specifically the visual impact of the development, and as a result, the decision was unlawful. The Court of Appeal, Lord Carnwath giving a leading judgment, the only judgment for the court actually, held that, in fact, no, it was a matter of planning judgment, agreeing with the High Court's decision that here, because as a matter of judgment, the inspector's view is that the visual impact of the development was far short of being so obviously material a factor that failure to address it expressly was an error of law. So in other words, it was open to the inspector to say, there is a visual impact, but I don't consider it so material that I ought to take it into account expressly. It was absolutely fine, perfectly lawful. And failing that, it was entirely a matter of planning judgment for the inspector or indeed any planning authority to take into account visual impact as they may see fit. So it's nothing more than a material consideration.
So thinking about that then, in terms of what are the implications of that? Of course, if the Supreme Court has underscored that this is a matter of judgment, this is a matter for the individual decision maker to decide for themselves. Does this mean that potentially we're going to get to a stage where there are going to be inconsistent decisions on these issues up and down the country, depending on where it's applied?
There's the potential for that, but I think the courts are very clear in cautioning against anyone attempting to make that an issue. So to be clear on that, it will be now a matter entirely for the judgment of planning authorities how they assess visual impact. And if they don't expressly consider it, it doesn't necessarily make the decision unlawful. But we have to remind ourselves that visual impact has always been a very subjective matter. So the broadening out of the way it can be approached by decision makers, by the Supreme Court, doesn't necessarily mean that we're going to get any more or less inconsistency across the country. We're just going to see perhaps a greater variety of decision-making styles by local planning authorities, because now they won't be as easily challenged. So if it's not expressly brought out in the decision, the local planning authority can turn around and say, well, in our judgment, it wasn't material. And so any potential claimant would have to prove that it was a material consideration. So much harder test because, of course, that's judgment. There's an inherent judgment call there.
Absolutely. Thank you very much for that, Nina. And of course, we know that Lord Carnwath has hung up his gown, hasn't he? So
yes, I was at the Supreme Court that day. Actually, it was very touching.
For his valedictorian speech.
I was, yes.
Fantastic.
All the great and good were there. I was not amongst them. I was hived off to a watching room.
Thank you very much for that, Nina. Chris, thank you very much for joining us. I was going to ask you about something that you have been intimately involved for quite some time, Rosewell Review, 1 year on. What was it actually supposed to achieve?
Primarily, it was seeking to speed up planning inquiries. Planning inquiries were taking up to a year to be heard, another couple of months for the decision as well. So 14, 15 months delay in the whole appeal process for inquiries, and that was considered completely unacceptable. It creates a lot of uncertainty for developers. They don't know what state the local plan will be, whether there'll be a neighbourhood plan, whether there'll still be a shortfall in the 5-year land supply, and the system needed to speed up, added to which planning inquiries, although there's only 300 of them a year, they deliver an additional 20,000 housing units in terms of the outcome of the appeals. So they're responsible for a lot of housing supply, and that system needed to speed up.
And so when we look at what has happened, and of course the decisions now has meant that you have these case management conferences, the topics are now being canvassed in a way that is slightly different. In practical terms, the day-to-day running of it, how would you say it's impacted the decision-making process?
I would say there's 3 big differences. First of all, the one I've already touched upon, which is speeded up the process. You get your appeal now within 16 weeks of lodging the appeal, and you get a decision usually within about 6 to 8 weeks after that. So it's much, much quicker. The second way is that to speed up the process, to speed up the inquiry itself, it's now a combination of conventional inquiry procedures with evidence in chief, cross-examination and re-examination, together with opening speeches and closing speeches. But some of the sessions and some of the topics are dealt with by round table, led by the inspector. The general belief is that will be quicker for certain topics, but that does vary, and we might come on to that in a bit. The third issue is that we have these case management conferences. They've been, as you know, something we had at court for 20 years now, but they are new to the planning system. And I think inspectors are finding them very helpful to understand the parties' cases, to start suggesting the way in which the inquiry will be structured. And I think it's helpful to everybody how those case management conferences can provide the parties with an early indication of what the inspector wants the inquiry to look like.
So, and finally, could you just tell us a little bit about first the criticisms that have been, of course, on Rosewell, but crucially, what does it mean for Rosewell in this sort of COVID-19 period?
Okay, so first of all, the criticisms have been, particularly from the development industry, that too many topics are being chosen as round tables. There are inquiries where the main issues have been landscape and heritage, and both of those issues have been dealt with by round table. And the feeling is that some inspectors have been too enthusiastic to go down the round table route when this is still an inquiry. If you have everything as round table, then it looks more like an informal hearing. I think the planning inspectorate have recognised that. They've rowed back a little bit from that. I've been involved in inquiries where inspectors, once they've seen the evidence, have been persuaded to go back to a conventional inquiry approach, even on topics like landscape. And sometimes inspectors will suggest a hybrid, even within the context of one topic. So you might have a round table and they will still allow 30 minutes of cross-examination afterwards. What all that means in the current climate, COVID-19, is obviously very interesting. The system had just started to get underway, and then suddenly we have all these restrictions on assembly. I think the key thing is that the planning inspectorate are looking how to progress inquiries. We don't know how long the current restrictions on assembly will last. And so there's a need to make sure the system keeps operating, which is what's happened with planning committees. The government have introduced legislation to ensure planning committees can meet remotely. You will know that the planning bar, the PBA, the Planning and Environmental Bar Association, has been working with PINS to encourage them to progress this. And I think we're at the stage now where PINS will start to trial a few inquiries and hearings by video conferencing, probably using Microsoft Teams. But obviously they are keen to ensure that everybody is involved. And that means making sure that some people can probably join by telephone or can provide their representations in writing and maybe given some more time to do that.
Thank you very much. And we'll see, obviously, what this means. PINS have been quite proud of their statistics of decision making being quite quick, but I doubt that that's going to be sustainable in this period. Thank you very much for those insightful thoughts, Chris, and we hope that you and your family are well.
Thank you, Hashi. Nice talking to you.
That was Christopher Young, QC, telling us about the Rosewell review. Thank you all for taking the time to listen to the first half of this Number 5 Chambers podcast. We will be back in the next installment to explore other matters, including case law update, what the planning for the future looks like, and what exactly are nitrates and how do they impact on development. Until next time, be safe, and from all of us at Number 5 Chambers,